This presentation discusses the basics of licensing data in the Minnesota Data Practices Act. Minnesota Statutes Section 1341 addresses licensing data. This statute dictates whether the data a licensing agency collects, creates, or maintains is public or not public. These classifications determine who can have access to various data. In order for licensing data classifications in Minnesota Statute 1341 to apply, it is necessary to determine whether the government entity that collected, created, or maintained the data fits the definition of a licensing agency in the statute. There are two requirements that an entity must meet to be considered a licensing agency. The first is that the entity must be a state, board, department, or agency. This means that local, city, or county boards or agencies are not addressed by the statute. The second requirement is that the entity must have statutory authority to issue professional or other types of licenses. However, there is one main exception to this definition. Agencies that are primarily administered by the Commissioner of the Department of Human Services are not considered a licensing agency for purposes of 1341, and instead, any data collected, created, or maintained related to licenses that are registered with DHS are considered welfare data. If you are interested in learning more about the classifications of welfare data, please refer to Minnesota Statute 1346, as 1346 will not be addressed in this video. After it is determined that the entity in question is in fact a licensing agency, it is then important to understand what the classifications within the statute mean. The first classification is public data. In Minnesota, the default classification for data is public. This means that unless there is a specific law classifying data as anything other than public or limiting access to that data, the data is automatically public and available to anyone for any reason. The next classifications are private or non-public data. Private data refers to data on individuals, while non-public data refers to data not on individuals. This classification limits access of this data to the subject of that data. Individuals in the entity whose work assignments require access, entities authorized by law, and anyone authorized by the data subject. This includes applicant data other than an applicant's name and designated address. The final classifications are confidential or protected non-public data. These data are not available to the data subject. In fact, these data are only available to those in the entity whose work assignment requires access, and any entities authorized by law. An example of this classification includes active investigative data relating to an investigation of a complaint against a licensee. All data that are not classified are public data by default. However, Minnesota Statute Section 1341 also specifically outlines certain data that are public or become public. For example, an applicant's name and designated address are public. Further, once an applicant becomes a licensee, the application data of a licensee is public, with a few exceptions, including non-designated addresses, orders for hearing, findings of fact, conclusions of law, and specifications of final disciplinary action contained in the record of a disciplinary action. Licensing agency minutes are also public. When there is a public hearing, the record of the disciplinary proceeding is public as well. If a licensee and the license agency agree to resolve a complaint without a hearing, then their agreement and reasons for the agreement are public. License numbers, license status, and continuing education records issued or maintained by the Board of Peace Officer Standards and Training are also public data. Minnesota Statute Section 1341 specifically outlines licensing data that are private. However, it is worth noting that there are other chapters of Minnesota statutes that provide additional classifications for data maintained by specific licensing agencies as well. Classifications that are listed outside of Chapter 13 are outlined in Minnesota Statute Section 13.411. Private licensing data includes applicant data while an individual is still an applicant, except for the applicant's name and designated address, as well as the identities of individuals who have made reports concerning licensees or applicants within inactive complaint data. The nature and content of unsubstantiated complaints are private, when this data is not maintained in anticipation of legal action. The identity of patients whose medical records are received by a health licensing agency for a review or in anticipation of a contested matter are also private. Inactive investigative data relating to violations of statutes or rules are private as well. Records of any disciplinary hearing are private except as limited by Subdivision 5 of Minnesota Statutes Section 1341, which outlines instances when records of a disciplinary hearing may be public. Specific data maintained by the Board of Peace Officer Standard and Training are also private, including the home addresses of licensees and applicants, and data that identify the government entity that employs a licensed peace officer. As stated previously, confidential data are data that are only available to those in the entity whose work assignment requires access and entities authorized by law. The data subject of confidential data does not have access to it. Confidential licensing data includes active investigative data relating to the investigation of complaints against a licensee. It is important to remember that all licensing data are presumptively public. This means that it is accessible to anyone for any reason unless it is classified as not public data somewhere in Minnesota statutes. As a result, in order to withhold or protect certain licensing data, you must cite to a specific statute that classifies this data as not public. If data are private, you may obtain a data subject's informed consent to release the private data about them to a third party. While the majority of applicant data are private while an individual is an applicant, it is important to remember that once an applicant becomes a licensee, much of the private applicant data in Minnesota Statute Section 1341 becomes public unless it is classified as not public elsewhere in Minnesota statutes. It is also worth noting that Minnesota Statute Section 1341, Subdivision 6, provides a health and safety exception for releasing private and confidential data. This exception allows any licensing agency to release private or confidential data to an appropriate person or agency if the failure to do so is likely to create a clear and present danger to public health or safety. Finally, licensing agencies may have their own classifications elsewhere in Minnesota statutes, so it is also necessary to determine whether the licensing agency maintaining certain data has additional classifications. Thank you for viewing this presentation on licensing data. This was only a brief overview of licensing data. If you are interested in learning more about the Minnesota Data Practices Act, please visit our website.